Generally speaking, after somebody has been arrested, they're going to have an initial appearance in front of a judge to determine their release conditions, whether there's going to be a bond, whether there's going to be electronic monitoring, pretrial services where you have to check in with someone, or whether you'll just be released on your own recognizance to come to court, when you're set for a hearing on your own. So that is all going to happen pretty quickly. Now, following that, the typical proceeding, whether it's for a misdemeanor or a felony criminal offense, is going to be within a couple of weeks having what we call an arraignment, where an official reading of the charges that have been filed by the prosecuting agency is done by a judge, and a plea of typically not guilty is entered at that time, hopefully with the assistance of a criminal defense attorney at your arraignment. Any changes in your original release conditions may be addressed at that time, and you're going to get some future court dates as well. So from the arraignment, after a plea of not guilty is entered, what's going to happen next is you're going to typically be set in misdemeanor cases for what we call pretrial conference. And there may be several of these before the case is actually resolved. In a felony case, you're going to be set for your initial pretrial conference. And at that hearing, you'll get future dates in your case. You'll get a comprehensive pretrial conference set 30 days after the initial pretrial conference, which is about 30 days after the arraignment. So you can see how the months are already starting to pile up in a felony case. And a comprehensive pretrial conference is essentially a point to check to make sure that the state has provided all the evidence, what we call discovery, to your attorney, that they've turned over any videos, photos, police reports, recordings in the case. By the time the comprehensive pretrial conference is over, typically a plea offer of some type has been made. There may be what we call a settlement conference, where a judge sits down and discusses the pros and cons of a plea offer. And then in the future, there'll be what we call a trial management conference, where the judge determines if everybody is prepared to trial. And a firm trial date will be up next, where you will potentially be picking a jury and going to trial in your case. Now, in a misdemeanor case, as I said, there's a pretrial conference that's set after the arraignment, typically about 30 days. And you can continue that or have multiple pretrial conferences throughout your case as negotiations are taking place and discovery is being passed back and forth between the state and your attorney. So at some point, a judge or the prosecutor will determine that a resolution can't be reached, and a trial date will be set in that case. The difference between the misdemeanor and felony cases is typically misdemeanor cases are on a faster time track because they're not as complicated as felony cases. And typically a felony case will set a firm trial date at the outset of the case, so you have some idea when and if you're going to have to make a decision regarding a plea offer. So there's a lot of checkpoints along the way in both misdemeanor and felony cases, a lot of information being transferred back and forth between prosecution and defense, and ultimately a lot of negotiating going on around potential plea offers or resolutions in the case that may or may not lead to avoiding trial. And in the situation where a resolution can't be reached and the only way to determine what happened is to place it in front of a judge or a jury, we proceed to trial.
For a free phone consultation, contact attorney Jared Allen in Phoenix, Arizona at 602-456-1982 or visit his website at www.jsazlaw.com.